I will start. Lordship, I'd like to mention item number 35. Dear Lordship, the bodies, they want to negotiate the matter. So if this matter be listed after the vacation,
Wait. Who is appearing for the other side?
no one.
Then why?
The bodies,
Service is complete.
it was published in the paper. And they have approached us, the Union of India, to negotiate the matter.
So this is a 37 application, appeal,
My lord.
section 37
My
appeal.
lord.
So why don't you want to do it?
Since they have approached us that they want to negotiate, that is why we are giving it them a chance.
But then why they are not appearing before?
Yes, Lordship, they are not.
They can negotiate everything and then appeal, but they are not doing it. Let's see when the matter reaches.
My please, Your Lordship, I beg to mention here in item 43. Here, there's a similar matter listed for Monday. It's a part heard, so I pray that this matter may be listed along with the civil revision.
Started
Yes,
before?
before this court, Lordship, and it's fixed on Monday.
Which item?
43.
83. This one?
Yes, Lordship.
This is the other matter where they filed an application for condonation.
No,
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 Lordship,
Lordship.
it is to do with the same subject matter with regard to the civil revision file which was taken up some 2 days back. With regard to the land issue that
Land issue. No, this is, we are referring to 40?
43.
43.
Oh, this matter.
Yes, Lord.
And why this is there? Oh, that is for that quashing of that
Yes,
thing.
Lord.
Yes,
You, who has come? You.
Yeah.
You have come for quashing.
No, they have come for the question.
You have come for quashing against a charge sheet.
Against
Yes, against the complaint.
Against the criminal complaint
Complaint they have
that has
filed.
been filed
Yes.
by us.
Chalo. Item number 40. But both cannot be disposed of by one single judgment. How does it have any relevance?
No, Lordship,
One is another case where
as far as
your case is bad.
yes,
Isn't
Lordship,
it?
yes,
I
Lordship.
gave you an opportunity on that day. Then,
but Lordship,
but this is another case.
Lordship, unless the civil revision is
Tomorrow Supreme Court will laugh if I dispose of one civil revision and criminal revision together. Isn't it?
Lordship, it may be listed together, not together. I mean, on the same day, not as analogous matter, but depending on the outcome of the civil revision. Let this petition be
Item
open.
number 43, when is the other matter? Free?
On 9.
9th.
Okay, this matter on 9th.
It's
Request of the learned counsel
civil revision.
appearing on behalf of the petitioner.
Lordship, Lordship, there is an interim. Interim may be extended.
Interim order passed earlier shall continue till the next date.
Lordship.
We'll take up the matters. Let us see.
Please, Your Lordship, I beg to mention here in
Matter.
item 34.
We'll take up the matters. We'll see when the matter reaches.
For admission, item number 1.
My lord, the contempt no longer survives.
Longer survives.
Yes, Lordship, so it may be closed.
At the moment, the learned counsel appearing on behalf of the petitioner submits that the contempt, the instant proceedings no longer survives in view of
Uh, Judgment order 12/3/2024.
view of the judgment and order dated 12/3/2024 passed by the division bench in
WA number
read
17.
appeal number 79 of the 2023, taking into account
Lordship 79, 80 and 81.
79
80 and
oblique
81.
2023, 80 oblique 2023, and
81.
81 oblique 2023. Taking into account above, the instant contempt proceedings stands dropped.
Lordship, my name may also be reflected.
Your name will be reflected on top.
Oh, Lordship.
Obliged, Lordship.
Madam, you reflect her name.
For admission, item number 2.
Lordship, here also similar order may be passed. Lordship.
Same,
Yes, but she left.
same order,
Yes, it's the same.
same order.
For admission, item number 3.
Lordship, here also same, similar order may be passed, but the council name is different.
Who is there?
Please, Your Lordship, I'm appearing on behalf of my senior Joshua Shike.
Same order?
Yes, same order.
Doctor.
Much good.
Obliged, my lord.
For admission, item numbers 4 and 5.
Appreciate Lordships. Lordships, I appear for respondent number 1, 4, 5, 6, and 7. Lordship. I may be given 1 week's time to file my affidavit in opposition
What affidavit? In a revision application?
to the IA Lordship.
IA?
There's a condonation of delay, Lordship.
Condonation, how much is the delay?
203 days, Lordship.
Huh?
203 days, Lordship.
But the applicant is not appearing earlier also. Why shouldn't we dismiss this for the non-prosecution? We wait for till the next time. If none appears on behalf of the applicant, we'll dismiss it. Better hoga.
Lordship. Much obliged, Lord.
We'll take it up after some time. First time it has come, the council is not here. We'll take it out again. If the council does not appear, we dismiss for default.
For admission, item number 6 and 7.
Please, Your Lordship. My lord, I pray that this matter may be fixed after 2 weeks.
Why?
My senior, he is on leave.
Hmm?
My senior, he is on leave.
You submit, I'll help you out. What is your case?
My lord, here the petitioner is challenging the
What is your case? Why the civil revision? They're challenging what?
the order passed by the district principal and district judge. Zuneboto.
Where is that order? Page 256.
Page number 256, annexure 24.
This IA,
Lordship, in civil revision 13, we are challenging the IA. Um,
this IA Civil 1 of 2024,
yes, Lordship.
is it an order passed in a suit or in an appeal? Yes.
My lord, I'm appearing on behalf of my learned friend Anikatu Watsa, who's the counsel for the respondent. I'm not in the matter, but to show his presence.
Lordship, even me, I am not in this matter. I'm appearing for S. Mary, Lordship. She has some personal difficulties today.
No, that is okay. Don't worry. First of all, tell me, is it in an appeal?
It
This
is,
order is passed, or is it in a suit?
my lord, in a suit,
In a suit.
yes.
Fantastic. So the suit was filed before the court of the district judge?
Yes, Lordship.
Does the district judge has original jurisdiction?
No, Lordship, on that ground also, we are coming before this court because of the jurisdiction. The respondent, they have to approach the DC or his assistant. However, they have challenging the Dubashi's order. They have appeared before the district court.
DC.
Yes,
So they filed a. so
they have
it
to
went
appear
to
before the DC. However, they have appeared before the district judge. Therefore,
So before the district judge.
yes, Lordship.
So they filed the suit there
Yes, Lordship.
against the Dubashi order.
Yes, Lordship.
So did they file under 31? Any application to the DC?
No, Lordship. They
No
didn't
appeal
file.
was filed.
Yes,
So
Lordship.
directly they filed a suit before the DC,
Yes,
the district judge.
Yes, Lordship.
And against that, this order is passed.
Yes, Lordship.
Now tell me, if an order is passed in an injunction application, wouldn't an appeal lie? 227 is not permissible. Isn't it? Now, it is in the suit. How do you file 227? We do one thing, madam.
Yes, Lordship.
We convert this into an appeal.
Lordship, I pray that this
It will
matter may be.
remain like this only. We convert it into an appeal because tomorrow you'll have the same problem. This remains as it is. Get the point?
This may be listed next week. My senior
Where
will be
is your
here.
senior?
Due to some family urgency, he went to village. He will be here next week.
No, this is a simple thing. Next week we'll take it as a MFA. We'll make it an MFA today and then we'll deal it next week. You see, the question is you are challenging an order. Now, there are many judgments of the Supreme Court which say that you cannot exercise 227 when there is a power given under Order 43, Rule 1R. An appeal lies against this. So we convert this, direct the registry to convert it and re-register as an MFA. So it remains as it is. But it will then we will be exercising our appellate jurisdiction. When we exercise your appellate jurisdiction, the power is much more than a 227. So your case would be much better. You can place your case better than in a proceedings under 227. So I am doing a favor to you. I hope you understand.
Yes, Lordship.
So we convert it into an MFA, the regular FAO, FAO. We convert it into a FAO and then direct them to be listed next week.
Lordship, Lordship.
So that the power will be much more for this court.
Yes,
The
Lordship.
scope of exercise of a jurisdiction, otherwise 227 has to be when it is shocking to the court.
Yes, Lordship.
But here we are going to decide if it is the order is erroneous, if it is unreasonable, if it is capricious. We can decide all these aspects when it is an appeal.
Yes, Lordship.
So I am helping you out. Okay?
Yes, Lordship.
Sure. And what is the other one? Same?
Yes, Lordship. These are similar matters.
Huh?
Similar matter. Here.
Okay, this is a different, this will remain as it is. This will remain as it is. We'll have this on next date. This remains as it is because this is against an order passed whereby your preliminary objections were rejected, isn't it?
Yes, Lordship.
So let this remain as it is. Just right here. Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent number
Respondent number 1, 2, 3.
3, and so-and-so appears on behalf of respondent number
4 and 5.
4 and 5. Full stop. The instant revision application have been initiated, the instant proceedings have been initiated by invoking the supervisory jurisdiction of this court under Article 2 to 7 of the Constitution. Full stop. However, this court have duly taken note of that the instant proceeding is directed against a judgment and order, against an order passed in exercise of the powers under Order 39, Rule 1 and 2, read it Section 151, in an injunction application arising out of civil suit number 1/2024. For a perusal of the material, it is a well-settled principle of law that against an order of granting or refusing injunction, an appeal lies under Order 43, Rule 1R, read with Section 104 of the Code of Civil Procedure. Full stop. Under such circumstances, this court converts the instant proceedings to a proceedings under Order 43, Rule 1R, read with Section 104 of the Code of Civil Procedure. The grounds of objection which have been taken in the instant revision application, more particularly at paragraph number 10, be read as grounds of objection in appeal in terms with the provisions of Order 41, Rule 1 of the Code. The registry is directed to re-register the instant application as an appeal. Full stop. And as an appeal, and list this matter before this court next week. Full stop. This court further grants liberty to the petitioner to file an application under Order 41, Rule 5 for stay of the order, of the impugned order, as well as filed appropriate application under Order 39, Rule 1 and 2, if the appellant, if the petitioners who are petitioners seeks any injunction. List accordingly. The next item, list this matter on that day, fix a date in both the cases. Madam, if you want an injunction, you are to file an application for injunction.
Yes, Lordship.
If you want a stay, you are to file an application for stay. I mentioned it.
Yes, Lordship.
Okay?
Lordship.
Monday.
Not mine, they made it on 10th. Then,
These are not disposed.
no, I've converted it.
For admission, item numbers 8 and 9.
May I please, Your Lordship?
Hmm.
Your Lordship, I beg to mention on behalf of my colleague V. Jimo, kindly let the matter come up after the vacation. He's yet to.
What are these?
Your Lordship, I'm not aware of. this
You are not
matter.
aware, fantastic. Who is filing this application? Who has
The
filed this application?
petitioners are also not here.
They are not here then? What is this order? What are they asking for? Let us see. So this is a quashing. Quashing of an application as regard theft. 379.
Your Lordship, I'm not aware of this case. I've just been informed a few minutes
Chalo.
ago.
None has appeared on behalf of them. What to do? where they fire. Yes, who is appealing? You are appealing?
Your Lordship, I'm appearing for respondent number 2.
Oh, you are the main person.
For the respondent number 2.
Who has filed a complaint?
Yes, Your Lordship.
Yes. Now tell me, one complaint you have filed it, who's I?
Your Lordship, my senior is on legs in court number 1. I need this, madam.
Huh?
They will
Let
pass
your
over.
senior come.
Yes, Your Lordship.
We'll take it up, let your senior come. What is the other one? State of Nagaland, what is the state of Nagaland doing?
Your Lordship, this,
Application filed under Iman praying for cancellation of the anticipatory bail order. Granting pre-arrest bail. Which order? 21/3/2024. Well, we take up both. First, if I set aside this, I quash the FIR, nothing remains. We'll take it up after some time. Let us senior come.
For admission, item number 10.
Neeraj, what is this?
Lordship, I from respondent number 2 and 3. We'll be filing our affidavit in opposition during the course of the day.
Huh?
I'm for respondent number 2 and 3. I'll be filing my affidavit in opposition during the course of the day.
Okay,
Lordship, on the last occasion, a last chance was granted to file an affidavit.
very well. Non-consideration of the petitioner's representation dated demand. Now, what is your case?
The petitioner is aggrieved by the impugned suspension order issued by the Deputy Chief Electoral Office, Nagaland Kohima.
Where is that order? He was arrested,
Right, Lordship.
whereas arrest intimation report of the year was done on Iman and another 3 months report of detention and were kept under police custody. Now you have been released on bail.
Yes, Lordship.
Did you intimate them? By this page 18, you intimated that you have been basing on the I was arrested and you have been released. Since my involvement could not be established, the Honorable Legislature had granted bail. Okay, so this was informed on when? 27/47.
Right.
And you are still under suspension?
Right, Lordship.
How is it possible?
Lordship, we're filing our affidavit.
No, not filing. Suspension is Article 21 violation. Thing doing. The judgment of Ajay Chaudhary is clear, isn't it?
Right.
You are basing on that?
Basing on Rafet Ahmed versus State of Assam.
Oh,
Right.
that is the judgment which I delivered? Isn't that the case? Wherein it says that when after informing, you have to inform them, and after that, within such and such period, 90 days, they are to submit the give you the charge sheet.
Right.
Isn't it?
Right.
Where is that? What is the judgment you are having with you?
Lordship, I have
Or you are
arranged for Rafet versus Ahmed's
you don't want your client to be remain, you want the client to remain under suspension.
no, Lordship.
Where is the what judgment you are having? You are flipping a lot of papers.
Right, Lordship. I just couldn't find the right one.
Give me any one. What is that? What is that? This is Ajay Chaudhary, yes. Then Ajay Chaudhary says about 3 months.
3 months, Lordship.
But Ajay Chaudhary does not deal with deemed suspension.
Right, Lordship.
Deemed suspension is a case in this present case.
Right.
Deemed suspension, it was therefore said in Rafed Ahmed, Rafed Ali, something to that effect. Saying that from the date you intimate,
Right.
within 3 months, if they don't submit the, what you call the charge sheet,
Right.
then the principles mentioned in paragraph 21 of Ajay Chaudhary will apply.
Right.
And therefore, he has to be removed from the suspension.
Right.
Isn't that the law?
Right, Lordship.
Lordship, if the matter can be heard next week and
Tomorrow.
we'll be filing our
Tomorrow,
Lordship. We'll be
you
filing
get that
it.
judgment.
Right.
This matter tomorrow.
Okay. Right, Lordship.
The learned counsel appearing on behalf of the respondent seeks a further opportunity. Like the learned counsel, Mr. So-and-so, the learned counsel appearing on behalf of the respondent seeks a further opportunity. So it is seen that on the earlier occasion, the respondents were given a last chance.
Right.
However, there has been no affidavit filed. The learned counsel appearing on behalf of the petitioner expresses urgency, taking into account that the petitioner has been under suspension for more than 1 year, 5 months. And as such submits that the same is contrary to the law laid down by the Supreme Court in the case of Ajay Chaudhary versus, what is that? Ajay Chaudhary versus
Union of India.
reported in reported 2015 7 SCC 291. Pusto. Taking into account the above, list this matter tomorrow. Pusto. The counsel appearing on behalf of the respondents shall apprise this court as to whether the charge sheet has been submitted. The charge sheet, memorandum of charge sheet have been served upon the petitioner in the meantime.
For admission, item number 11.
Mr. Counsel, you get that Rafed Ali judgment. Here, what is this?
I am for respondents 2, 3, 6, and 7. My affidavit is in the process of being notarized. I'll be filing tomorrow, my lord.
Is in the process of being notarized, and does the notary stay somewhere else in
No, in
the
Kohima.
country?
No, in Kohima, lordship.
So to
Will
you,
be-
why
will be-
can't you file it today?
We'll make efforts, lordship.
What is your case?
I'm seeking additional compensation to the damaged properties.
Directing restaurant to conduct joint spot verification and bring out assessment of the damaged properties, directing the respondent authority to pay compensation for the damages. What is this? Who has damaged yours?
The NDPS.
Oh, he is NHL DCL.
Yes, lordship.
And whom are you asking that they should make a joint here? Is it something to do with those lands? Dimapur, Kohima?
Yes, my lord. Yes, my lord.
And then I delivered one judgment, and NH, what is that? Mr. Takamaso was there.
Our land starts from Old Patkai Bridge.
Why the same principle shall not apply? You see, the question is, there also I directed. It said the reported judgment, NH 29 or 39, yeah, this one?
Here, lordship, we have already paid damage compensation to them, lordship, earlier.
Understood.
Yes.
Whatever may be, you see, these things, this court can't do it.
Yes.
What I said in that thing, they will make an assessment, they will make a verification. If
Lordship.
they find that they are not entitled to any compensation, they will come up and say that.
Lordship,
And if they say that, and if they say there is a compensation, then you will take care of it.
lordship.
And if they say that if they are not entitled to any amount, then they are to file a suit.
Yes, lordship.
That is what my direction was
Lordship,
in that
lordship.
NH 29 Landowners Association. Ask Mr. Takamasu, he was there.
My lord. Lordship.
And it is reported somewhere. I've
Lordship.
seen it. So we can incorporate that and finish it off.
Yes, my lord. Yes.
He wants that. What do you want? You want directing a joint spot inspection.
Yes, my lord.
That would be given.
Yes, my lord.
Now, we will direct them that if under inspection and verification you are entitled to the amount, they will pay. If they feel that you are not, then obviously you have to file a suit.
Yes, my lord.
That is.
Yes, my lord.
So see that judgment. We'll take it up tomorrow.
Lordship.
It's reported.
Lordship.
Or ask Mr. Takamasa. He
Lordship,
knows
Lord.
it.
I'll
You
get
were
it.
there.
I'll get it, Lordship.
Did you appear? No. Oh, Mr. T.B. Jamir appeared, I
My
suppose.
lord.
He was then, I think, the additional advocate.
In this case, I'm for the state respondent. I received the additional affidavit. It is a process.
Okay,
So I
list
have
this
to
matter,
receive the
list this matter again on 12th of December 2024. In the meantime, the respondents shall bring on record their stand by filing their affidavit on or before 10th of December.
My lord.
You get that judgment. It's reported in ZLR.
For admission, item number 12.
Yeah, what is this?
That is a lordship. Lordship, I'm mentioning on behalf of my senior, my intern lordship. Lordship, I have been instructed that he is in imprisonment, lordship. Yes,
First and foremost, Mr. Zimomi,
lordship.
in these cases, these people, the petitioner's allegation is they have been terminated on 9th of September,
August.
9th of August, at the time of paying them their 22 months of salary. And that is giving effect from 1st of January 2024.
Lordship.
That's it.
Lordship.
That is why the petitioners have asked for challenging the termination orders. With due respect to my learned brother, the moment there is a termination, there is a cessation of employee-employee relationship. So under such circumstances, they cannot be kept. But the matter requires an urgent disposal, taking into account if you have terminated with notice or without notice. If you have not done it without notice, we have to set aside. So the question therefore is a simple question: did you do it with a notice? Because, or is it because that they have filed a writ petition asking them to get this 44 months of salary? You have given them 22 months of salary and said that, okay, pack your bags and go. Simple. We'll have it on 10th. Get all the affidavits. That's your 10th. Only question is whether they had issued notice or not.
Lordship, they have not issued the notice.
Huh?
Without following the due process of law.
That is what?
Lordship.
So simple question is that.
Yes.
So if that is so, we have to set aside. But Mr. Counsel, you also have to understand, the interim order is not going to help you this one. First of all, we cannot suspend or stay as termination order. Because that is an end something. Tomorrow, if the writ petition is withdrawn, what happens? We can't put the court back to a particular position. So we have to dispose it of. They have been given instructions out there, so they are to produce the instructions or come up with any affidavit, they stand what they have to say. We'll have it on 10th or 11th.
Lordship, since only a few days left for this court.
Mr. Counsel, if their affidavit was there, it would have been disposed of in 15 minutes.
Lordship, but there is no instruction from, and then I'm also informed by the other advocate that he has no further instruction. So let the matter be listed immediately after the litigation.
Why?
Because I have some preoccupation in the next week. Okay.
Oh,
so
Chalo, I was doing you a favor. But anyways, you
and
want
Lordship.
You want your agony of your client to further be there. I can't help it. Mr. V. Jimomi appearing on behalf of the Learned Council, appearing on behalf of the state respondent 6 for an accommodation for filing their reply. Full stop. The council appearing on behalf of the petitioner has no objection. List this matter after vacation.
I'm mentioning on behalf of my senior, my intern.
I only see you.
Lordship, deal that they then be.
What interim? That interim, absolutely. How can there be an interim? There is already a cessation of relation with the termination order. If there is a cessation of relation, how you have already been ousted, isn't it?
Yes.
If you have already been ousted, then where can there be an interim order that if you are not ousted, you would maybe continue?
Lordship.
You have already been ousted.
Lordship, that is why I have clearly made that submission on that day that since the process was not taken as per the law, no notice was taken.
Therefore, Mr. Counsel, your case should have been in to take up the matter at the earliest.
Lordship.
If no steps was taken, we set aside everything, then you get everything.
Lordship.
But your occupations
Lordship.
supersedes the interest of the client, what to do?
Lordship. Tell you next week, Lordship.
Next?
I'll.
You have your next week, whenever any of the 75 days, we finish it off. Because it seems on the face of it, you have a good case.
Lordship.
But the fact that they have not done it, I would have disposed it of today itself.
Lordship.
But the fact that he has not, the council, who is the council?
Mountain.
He's not here. But if he doesn't appear on that date, it will finish. And it is the state, we still have the Advocate General nearby. I saw him entering. I'll ask him to appear. Matter over. You get your order. You see, at last you give something good news to your client during Christmas. Or if you wanted that he suffers during the cold winters, it's uncovered. Because there is a direction to pay. They have also come up with a categorical finding to that effect that you are entitled for that. So obviously you are entitled for that also amount. So there is an order which has been passed by this, which has not been adhered to. So you have a good case. But you know, these matters, if it is delayed, it affects, like in the principal seat, whenever these type of matters come, we immediately finish it off. The reason is otherwise the people, certain termination matters, if it goes out of the hands, if it is done, then this person is going to suffer for 2-3 years. Here it will be 1-2 years maybe, but in principal seat 8-10 years.
And then
Because nobody wants to entertain this. Okay, why should I go ahead and dispose of? It will take some time and all. But I believe in short, crisp orders.
Lordship, moreover, that they have taken shelter on the Rule 5 of this CCS 1975. With thereby, in that it is categorically mentioned that at least 1 month should be given.
That is what. First of all, without notice, how can you? And this is, if it is a case of compulsory retirement, go for it. But compulsory retirement has also to be adjusted on the basis of something. You can't go for a compulsory retirement in this. And if it is a compulsory retirement, you are entitled to all the pensionary benefits. These are various aspects of the matter. So you have a good case. So what do you want? It depends solely upon you.
Actually, as I said, I have already a pre-plan.
Okay, chala. We'll have it after vacations. Okay. Let's keep that same order after vacations.
Like same order with the remaining logic. Same order. Field music.
Item number 8 and 9 for admission. Registered.
Maybe Lordship.
Yes, what is this?
Lordship, I'm agreeing for respondent number 2.
Hmm.
Lordship, this morning I've been informed by my client that they are taking step to compromise.
Compromise or no compromise? First of all,
settlement is
when
going on
you have
between.
already filed a case before in Hojai,
That is already been withdrawn, Lordship.
then it is being withdrawn by you.
No, by the petitioner.
You filed it.
No, Lordship.
Who filed that Hojai
The
case?
criminal petitioner. The petitioner filed the criminal case at Hojai, Lordship. That was
Okay, so
withdrawn.
he withdrew it.
Withdrawn, Lordship. I have the order, Lordship.
And then
an FIR which was lodged at Jammu Kohima, Lordship. Lordship, they are taking steps to withdraw that FIR also. Therefore, Lordship, may I believe that this matter was listed on the application. That is the information I've received this morning, Lordship. So far as the Hojai case is concerned, that has been withdrawn, Lordship.
That has been withdrawn.
Lordship.
Okay, withdrawn by him.
Yes, Lordship.
And then thereafter you filed this thing.
No, before that, Lordship. Before that, I filed the FIR. Subsequent to filing up the FIR, the petitioner filed the criminal case at Hojai. That has been withdrawn, Lordship.
But did you enter into any agreement with him?
No agreement, Lordship.
So he just took the dumper.
Dear Lordship, in fact, dear friends, Lordship.
Otherwise, from this FIR at page 21,
Lordship.
which is quashing, if there is nothing out there, means first of all, from here you cannot quash it. Because this is a case of 379. How do you quash it? You are making an allegation. A case of 379 is made out. Whether in the trial something happens or not, that's another aspect of the matter. So why should they just stay? There's a stay to the
No, Lordship. There's no stay.
investigation? No.
No stay, Lordship.
Okay, but he has taken a bail.
Lordship.
And the state has filed an application for cancellation.
Lordship. But then, Lordship, the facts remain that settlement is going on between the parties. So my humble prayers for listening of this case of application, so that in between, Lordship, something may happen.
Okay, Mr. Watizami, the none appears on behalf of the petitioner on call. Mr. Watizami, the legal counsel appearing on behalf of the respondent submits that he has instructions from his client. There's some sort of negotiation going on between the petitioner and the respondent number 2. And as such submits that some more time may be granted to list this matter after the winter vacations. And the bail, what do we do? They are negotiating. Who are you? Why are you causing any trouble now?
Obliged, Lord.
It's another matter, no? 9. Where's the item number 9?
The council does not come.
Huh?
The council does not come.
No, not necessarily. 9 is the state's application, no? The state of the Nagaland versus
Yes.
so and
Item
so
number 9.
for cancellation of the
Yes,
bail.
Lordship.
So
same
what
matter-
remains here?
Same matter, Lordship. For the interest of all the parties. I'm not here as a party respondent here, Lordship. But then in view of the negotiation, Lordship. Once the negotiation is done, this criminal petition will get in process.
Have you taken steps? Huh? Mr. Jimomi? After issuance of notice, have you taken steps? To stop, Mr. V. Jimomi, the learned counsel, learned public prosecutor appearing on behalf of the petitioner, submits that pursuant to the order dated 15/10/2024, steps have been taken in the instant proceedings. First, be that as it may, nothing is reflected in the office note as to whether the surveys of the notice have been effected upon the respondent. First, the registrar shall make necessary inquiries and then thereupon list this matter.
For orders, item number 27.
No, please, Your Lordship. Your Lordship, service upon respondent number 3 is still awaited.
Huh?
Service upon respondent number 3 is still awaited.
You have taken steps?
Yes, Lordship. On 18/11/2024.
What is the office note say? Notice issued of the respondent return service awaited. With the service awaited as regards to contempt number 3. Who is the contempt number 3?
Newly implemented director, my lord. Smithy V. Lobilisema.
Yes, yes. You were appearing for whom? You were appearing for somebody earlier?
No, Your Lordship, in fact, for some respondents, I have been informed by S. Mere that some of the respondents asked her to appear on their behalf, Your Lordship. But as far as what respondents is concerned, Your Lordship, that I am not aware of it, Your Lordship.
Submits that
Otherwise, I have got no instruction to appear on this matter, ma'am.
submits that from the office note dated 21/11/2024. It is seen that the service upon the respondent number 3 is awaited. This will list the matter after completion of service upon the respondent number 3.
Obliged, Lordship.
Obliged.
For orders, item number 28.
Service upon the respondents are still available.
Waited? Okay, same order. This is office note dated 21/10. This is such a old office note. Why they have given it? No, the registry has not updated pursuant to the order dated 12/11/2024 as to whether the service upon the respondents have been duly effected. First to list this matter. The registry shall make necessary inquiry and place this matter before this court on 12th of December 2024. Insofar as the service upon the respondent numbers 1, 2, 3.
For orders, item number 29.
Criminal petition, none appears.
My lord, I'm appearing on behalf of counsel for the petitioner. My lord, I was instructed that
To withdraw?
no, your lordship.
Yes. Tell me.
Respondent number 2 is out of station, your lordship.
Who?
Respondent number 2, opposite party. They are going to take step through Dusty, but I was informed that respondent number 2 is out of station.
We stay this investigation. Then he will appear. This is out and out a civil dispute. Don't you think?
Lordship, since I don't have the brief.
Give him a copy of that FIR.
My lord, I'm appearing on behalf of counsel for the petitioner as well, my
My
lord.
goodness. Very sorry state of affairs, huh? And you have entered into compromise also.
Yes, my lord.
And why he is not appearing?
My lord, I was informed that respondent number 2
Not
is out of
appears on
station.
behalf of the petitioner or petitioner. First of service also upon the respondent is number 2 not affected. This is the matter of applications.
Obliged Lordship. For orders, item number 30.
Yes, Your Lordship. Your Lordship, by order dated 4/11/2024, we were instructed to take to serve notice through taxi service and registered post. However, Your Lordship, the respondents have refused to accept it.
Service not complete leads the matter of the completion of service.
Much obliged, Your Lordship.
For admission, item numbers 4 and 5. Relisted.
Please, Lordship. Lordship, here I'm appearing on behalf of the leading counsel for the petitioner, Eviction. Lordship,
Huh?
Eviction. He's the leading counsel in this case, Lordship.
You are appearing for
Eviction, the leading counsel for the petitioner. Lordship, I've been-
applicant.
Applicant, Lordship, please.
Yes, why the delay?
Lordship,
What is the delay business?
Lordship, I'm not aware, Lordship.
Eh?
I've been informed that he has some personal difficulty today, Lordship. So if
For
he's-
what? First of all, he does not appear. What is this? Delay of 203 days. Isn't it?
Lordship,
Eh? Why the delay? What have you mentioned? Was dismissed by the year after hearing the preliminary objections there. The applicant received the order of remand in the second week of January. That having misplaced, the council applied for certified true copy of the EA only in the last week of February. There was a large group of people. The consent of all the group was required to initiate further steps, and that it took about 4 months to deliberate and give consent thereafter. The deferred respondent, yeah. How many applicants are there? There are 2 applicants. What is this type of statements being made? Number 5, the applicant petitioner were representing a large group of people. The consent of all the group was necessary to initiate further, and therefore the petition could not be filed for filing the present revision. However, since the matter was complex and took 2 months past the necessary documents. You have to file an appeal. This is against what order?
I guess the order passed by the civil judge, Junior Division Tag, Lordship, dated 14/12/2022.
Thereby dismissing the suit.
Lordship.
Then how is the revision maintainable? How is the revision maintainable?
Lordship, I'm not a counsel in this.
Then none appears. We dismiss it on that ground. How is the revision maintainable? A suit being dismissed means it's a decree. So an appeal lies.
Lordship, if this matter can be passed over for tomorrow, Lordship.
This matter tomorrow. We dismiss it tomorrow.
Obliged, Lordship.
For hearing, item numbers 31 and 32.
Mr. Counsel, I just put your statement and argument here. Mr. So-and-so, the learned counsel appearing on behalf of the applicant, appearing on behalf of the respondents, submits that the instant application for condonation of delay requires to be dismissed, rejected, for the ground that the reasons assigned in paragraph number 5 of the application does not show sufficient cause. In addition to that, the learned counsel submits that when the suit has been dismissed on preliminary objections, it is a decree, and therefore an appeal has to be filed and no recourse to a proceedings under section 115 of the code can be taken. He therefore submits that the instant application for condonation of delay as well as the revision application be dismissed, be rejected at the forthwith. The counsel appearing on behalf of the Mr. So-and-so, who appears on behalf of so-and-so, your counsel for whom you are appearing, submits that he has no instructions in the matter and to therefore request that the matter be listed tomorrow. So list accordingly tomorrow.
Much obliged, Lordship.
You dismiss it.
Lordship.
Yes, what is this? Item?
Item numbers 31 and 32.
Yes, 31 is your matter. Mia.
Yes, please, Your Lordship. I'm appearing for recent NIA investigation.
You are the NIA.
Sir, it's a writ petition. Item number 32 is a writ petition filed by the petitioner against the cognizance. I'm the NIA, sir.
What is this challenge? Challenging what?
Actually, they are challenging the cognizance and the sanction order.
Okay, then who is appearing?
I suppose here, sir, on the last date, the trial court record was called by the predecessor court, but I think it's not been sent yet.
But why nobody is appearing? This matter is going on for such a long time. Is there a stay?
Sir.
There is a stay to the proceeding?
Yes, sir, there is stay. Yes, sir.
And why the matter was taken up by the division bench and then single bench? What is this? Anything? Huh? Mr. Counsel?
Sir.
Mr. Counsel? Are you aware of the matter? Are you aware of the matter?
Sir, it's about me?
Yes, about you. Because none is appearing for the petitioner.
Yes, sir, it's about sanction and petitioner is not appearing, sir, for the last 2-3 days.
Petitioner has not been appearing. Why the matter come up of 2023 and the matter has not come up since then?
The main counsel is not appearing. Some
okay. None appears on behalf of the petitioner on call. Full stop. Mr. So-and-so appears on behalf of the Mia. Full stop.
And for respondent number 3 and 4,
Mr. So-and-so appears for respondent number 3 and 4. Earlier I heard this matter somewhere, no?
I'm not remember mine.
My orders are there, na? 29/11/2022. Let the matter be listed again on so-and-so for further hearing. And there is so-and-so, the learned counsel appearing had heard at length yesterday as well as today. Counsel submits that he needs to take instruction as to whether he would like to proceed with the instant proceedings. 29/11/2022, again I heard, 28, again heard, heard. Then what happened? Somebody died in his family, so he left on 30/11/2022. Here, isn't it the case? He has challenged some notification of UPA? No.
Sir, you're very right, sir.
This one, na? Where
yes, sir. Your Lordship is right.
Was brought within the fold of what do you call the UPA. Because
yes, unlawful activities.
I asked the specific case that unless you are a member of that organization, can you challenge it?
Sir. Your Lordship is right, sir.
It was heard at length by me, and thereupon, for one reason or other, the matter got deferred.
Yes.
Therefore, I did not pass any order of extension of the interim order. I was not satisfied. You see,
but thereafter it was.
I left on 8/12 when the matter came, the operation of the interim order was continued.
Yes, yes.
Okay, none appears on behalf of the petitioner on call. Mr. So-and-so appears on behalf of the respondent respondent National Investigating Agency. And Mr. So-and-so appears on behalf of the respondent number 3 and 4.
Yes, ma'am.
First, for the ends of justice, this court have duly taken note of the averments made in the writ petition, and the fact that the matter was heard at length at one point of time. However, taking into account that the petitioners, after having obtained the interim order, have been delaying in the disposal of the writ petition, either by not appearing or by seeking adjournment, this court is not inclined to extend the interim order passed in the instant proceedings. Full stop. It will list this matter after vacation on where the February, January list. On 27th of January 2025. Full stop. It is made clear that if the petitioner is not represented on the next date, the instant writ petition will be dismissed for non-prosecution.
For hearing,
Obliged.
item number 33.
Yes.
May I please, Your Lordship? I'm appearing through VC, Your Lordship.
First of all, I can only see your forehead. Yeah, better. Tell me.
Lordship, due to some medical emergency, the principal counsel for the appellant has left for Hujai. So I humbly pray before this honorable court that
Medical emergency, one goes from Dimapur to Hosai. Dimapur has better medical facilities and then he goes to Hosai, which doesn't have.
yes, Lordship.
Give us a better example. What is this? This is an appeal against an award. Where's the award? Who has filed the appeal? Tata.
We have filed the appeal.
Let us see what case you have. You got the money?
I am for the claimant.
You got the money?
No, Lordship.
Not a single penny?
No, the half was deposited. I have received it.
Half you have received?
Yes.
You want the remaining?
Yes, Lordship.
Yes.
Lordship, this is about a tax policy, which was not issued from the appellant office. So, Lordship, if this
Your objection which was made was there was no accident. There was no rash and negligent driving. That is what the objection. Let us see your written statement.
Yes, Lord.
What does it say?
It is part of my written objection, Lordship. I will close that.
We have received the summons, written statement here, 3 and 4.
Not a whisper, Lordship.
Huh?
Did not made a whisper.
It is what was plying in contravention to the provision at the time of the accident and had not satisfied the requirement of Rule 3 on merit, so and so, nothing. Narration of the occurrence of and the date of the deceased is denied. The claimants are put to strict so and so, so and so. Monthly income of rupees or other are highly excessive, so and so, so and so, so and so. What is wrong? Nothing is wrong. You never said that there was no insurance policy.
Lordship, I don't have the brief with me, so.
No, none appears we dismiss for default. Which one
No,
you?
Lordship, no, Lordship. In that case, Lordship, if this matter may be accommodated on 10th of December.
Hello, ask him to appear in person.
Yes, Lordship.
Because 10th of December, I am dismissing another one of your Tata AIG.
Yes, Lordship.
Where he has filed an affidavit application for delay of 321 days.
Yes, Lordship.
Without proper explanation.
Yes, Lordship.
We have it on 10th, no, not on 10th. 10th, 10th. We'll have it on 10th.
Sorry, please.
Much obliged.
The counsel appearing on behalf of the appellant expresses inconvenience and requests the matter be taken up on 10/12/2024. The counsel appearing on behalf of the claimant submits that the matter, the instant appeal has been pending since 2020 and the award was passed
in 2019
in the year 2019. The claimant have only received 50% of the, and as such, the matter requires an urgent disposal. Taking into account the above, list this matter. The counsel appearing on behalf of the claimant have also to apprise this court the award as well as the pleadings which led to the award. Taking into account the above, list this matter on 10/12/2024, on which date this court will make an attempt to dispose of it.
Yes.
Much obliged.
For hearing, item number 34.
Yes, madam.
Your Lordship, I'm appearing on behalf of the counsel for the petitioner, Your Lordship.
He is not appearing. Why are you appearing? Last time also he didn't appear. 1911, no one appears.
Your Lordship, it's my humble prayer that it may be listed on 13th of December, Your Lordship.
When?
13th.
Why the last day? Why? What is this case? Where is the other? You have no opposition today. What is the case about? These to rule institute by quashing and setting aside the impugn order. They did say, what is the impugn order? Eviction. Like the 10 edition of the stated proceedings based on the vote on the You are not a tribal?
Your Lordship.
This person concerned? Not a tribal? How is 165 included? Not a scheduled tribe?
Your Lordship, I'm not in this case, so I'm not aware.
Oh, none appeals. Okay. None appears on behalf of the petitioner on call. Mr. Jimomi, you are appearing?
Lordship.
Mr. V. Jimomi appears on behalf of the respondent state. Posto.
Your Lordship, there is an interim in this. There's an interim. I was
No
informed that
extension.
there's an interim, Your Lordship.
Extension of interim. If the person, the interim is always till the next date. Okay. Now, last date, none appears least after 2 weeks. There's no interim. So there's no interim. Why should I extend? Yes, Mr. Jimmy, tell me. None appears. You have no opposition on this side then. You are concerned with an eviction proceedings initiated
Lordship.
by an order on the 7th of October. 7th of October is the order by which you have been asked to vacate under 165.
Lordship.
But Mr. Jimmy, tell me, 165 action, how can you take of the Assam Land and Revenue Regulation? 165 falls in Chapter 10 of Assam Land and Revenue Regulations.
Lordship.
Chapter 10 is protection of land for scheduled tribes. Now, if they are the petitioners are scheduled tribes,
Lordship.
how can you exercise 165? Enlighten me.
Lordship.
And
We are not disputing to the fact that they are not, they are also a scheduled tribe. Lordship. However, Lordship, then
so you initiated action under Section 5(1) for illegal possession.
Lordship.
Was issued under so and so belonging to the district hospital. Against the notice, a reply dated along with documents was received by this office. However, on perusal here was found to be in illegal possession of a public land.
Lordship.
Therefore, eviction order under Section 6 was passed of the Act. Regardless of the fact of the order dated 7/11/14 was passed, which was 18, which is final in nature. The said and resubmitted a so-called. Whereas subsequent to the when the then additional unit reinstated the proceedings afresh. And as such states here. Okay. So he was asked to vacate.
Lordship.
Against that, appeal lies
Lordship.
under Section 9, I suppose.
Lordship.
Take out the Nagaland Public Premises Act. Hello, one dismissal, I get it. Take out the Nagaland Public Premises. I'm coming back. Take out it.
He does not order. Three hands for us. Three hands for us.
Mr. Jimumi, what is this? Kindly come to page 35. Serial number 5. This is the petitioner.
It's at the back of the.
Writ petition.
Logic,
Retired staff, retired in the year 2009,
logic.
shop outside her quarter, case pending under DC. What is this case pending? Okay, now I get the point. This is because of that judgment which I delivered, wherein it says that DC could not have done it when there was a complete ban. Isn't this the case? And the flow of title which the petitioner is saying is on the basis of a title conferred by the DC by regularizing it when there was a complete ban. And thereupon, from there, it traveled to the petitioner. There was a title by way of a deed of sale being executed from the person who got it regularized. And as such, it was on the face of it illegal. So this land comes under dark number 416, which was a government land. And as such, you have taken action against this.
By issuing an eviction order.
Yes. But isn't it necessary for you to write all these things in your order rather than passing it mechanically? They have submitted a reply. So against the reply, isn't it required to not to just say anything in the printed, but apply your mind and say these things in the order? Isn't it the requirement of law? We do one thing. We set aside that order by which it has been declared against you, against them, and giving you the opportunity to pass an order, taking into account the contents of the affidavit. I think it would be better.
Logic.
We will pass an order, give him an opportunity of hearing, and pass an order. Then you pass this order under section 5, section 6.
Your Lordship, it is my humble prayer that it may be listed tomorrow then, Your Lordship.
Madam, I'm
In the
allowing
meantime-
your writ petition. I'm allowing your writ petition. I'm not dismissing your petition. I'm allowing your writ petition. You say that you were not given an opportunity of hearing.
Yes, Your Lordship.
That is the basic reason. You say that the particular land in question is a patta land of yours. You have purchased it. So, therefore, whenever you pass an order, the order has to have due reasons. It was made mechanically. without affording you opportunity. That is your case.
Yes, yes.
I'm allowing all your points. And thereby stating that we set aside that order and allowing them to issue notice, or the notice is there. You can submit your reply, or your reply is already given. That reply shall be given consideration, and along with that, you will hear you opportunity and then pass order. Can you get a better order than that? Then it's the best order you can get. It is more than the reliefs you are asking for. You only ask for setting aside this. I'm giving that even an opportunity of hearing is to be given before passing an order. I'll give another 30 days thereafter, 15 days thereafter, after the passing of the order, for you to file an appeal. What else you can get? Now can I put your name as the counsel appearing on behalf of the petitioner?
Your Lordship, my name is not in the Vakalat number.
So what? You want to sign it? The wakalat naman. Chalo. Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. V. Jimomi, the learned counsel appearing on behalf of the respondents numbers 1 to 4. Petitioners, the instant application, the instant proceedings have been initiated by invoking the extraordinary jurisdiction under Article 2 to 6 of the Constitution, challenging the order dated 7/10/2020 passed by the Deputy Commissioner, Dimapur, whereby the petitioner was directed to vacate the possession over the land as specifically described in the said order within a period of 15 days from the date of receipt of the said order, and further observing that in the case the petitioner fails to comply with the aforesaid directions, it would entail physical eviction with use of necessary force. The legality of the said order dated 7/10/2020, hereinafter referred to as the impugned order, has been questioned by the petitioner on the ground of that the said order suffers from non-application of mind, violation of the principles of natural justice, as well as the order being unreasonable and arbitrary, for which and accordingly in violation of Article 14 of the Constitution. For understanding the dispute involved in the instant proceedings, it is relevant, however, to take note of the facts leading to the filing of the instant writ petition. The petitioners herein claim to be the absolute owners of a plot of land at measuring 0 biga 1 katha 10 lechas, covered by Dag number 1259/1602 under Patta number 1309 at Dimapur under block number 6 and Moza number 1. The petitioners claim that the said ownership over the land in question was obtained on the basis of a deed of purchase, deed of sale, registered deed of sale, executed by one Kusika Aomi, dated 10/10/2011. It is the further case of the petitioner that pursuant thereto, the petitioner number two, nah? So, Jumami, the petitioner number 2 was issued a patta by the Revenue cum Settlement Officer, Office of the Deputy Commissioner, Dimapur, as well as was also given the land revenue clearance certificate in respect to the said land. Next. Be that as it may, the respondent number 2 had issued a notice under Section 5(1) of the Nagaland Eviction of Persons in Unauthorized Occupation of Public Land Act 1971, bracket the Act of 1971, on 21st of May 2012, asking the petitioner to show cause as to why he should not be evicted. Asking the petitioner, number 1, to show cause as to why she should not be evicted in view of the fact that the land the petitioner number 1 was occupying was a public land belonging to the medical department. Upon receipt of the said notice, the petitioner number 1 submitted a reply, detailed reply, stating inter alia that the land was purchased by the petitioner by the petitioner number 2. On the basis of a deed of sale executed dated 10/10/2011. It was further mentioned that the proceedings so initiated under the Act of 1971 was totally misconceived, and accordingly requested the respondent number 2 to drop the said proceedings. Be it as it may, pursuant to the said reply so submitted, after 2 years, therefrom, an order was passed on 7/11/2014 by the respondent number 2 in exercise of the powers under Section 6 of the Act of 1971, read with Rule 165 of the Assam Land and Revenue Regulations 1886, and thereby directing the petitioner number 1 to vacate the said plot of land after removing all structures or properties thereof within 15 days from the date of publication of the said order. Full stop. The petitioner, upon receipt of the said order, dated 7/11/2014, submitted a reply, again, reiterating its contentions as stated in the earlier reply so filed on 4/6/2012. Full stop. Subsequent thereto, after 6 years, on 7/10/2020, an order was passed, thereby observing that the petitioner were not required to submit a reply to the order passed under Section 6 of the Act of 1971, inasmuch as while the order dated 7/9/2014, 7/11/2014, the petitioner was already directed to vacate the premises, the public premises. However, by the impugned order dated 7/10/2020, the petitioner was given an additional period of 15 days to vacate, failing which action would be taken for carrying out physical eviction with use of necessary force. It is under such circumstances the petitioner approached this court by filing the instant writ petition. Full stop. This court, by an order dated 29/10/2020, issued notice and further directed that till the interim order, the petitioners be not evicted from the land in question. Full stop. The interim order thereupon have been extended from time to time. The respondents thereupon filed their detailed affidavit in opposition. From the said affidavit in opposition, the respondents have questioned the maintainability of the writ petition on the ground that an appellate remedy was available under Section 12(1) of the Act of 1971. Further to that, it was mentioned that the land in question belonged to the medical department. The land in question, which further it was mentioned that the land in question is a part of dark number 416, which belonged to the medical department of the government of Nagaland. It was further mentioned that after perusal of the replies so submitted along with the documents, it transpired that the vendor of the petitioner did not have a title over the land, inasmuch as the deputy commissioner had regularized the title of the vendor of the petitioner, namely Sri Veto Awomi, by an order dated 6/11/2004, but 11, first of. It is also mentioned that at that relevant point of time, the deputy commissioner had no authority or jurisdiction to do so, inasmuch as there was a complete ban by the government of Nagaland. It was also mentioned that the said issue have also been settled by the division bench of this court in the case of State of Nagaland and others versus Evio, Nalio and others, reported in, I think this is a reported judgment somewhere. Reported in so and so by the judgment and order dated 23/5/2022 in the case of State of Nagaland and others versus Evio, Nalio and others. It was therefore mentioned that when the vendor of the petitioner did not have a title and it was wrongly regularized by the deputy commissioner who had no authority to do so, and the land in question was a public land, and as such, the exercise of jurisdiction by the respondent number 2 was in accordance with the provisions of the Act of 1971, for which the instant writ petition ought to be dismissed. It is further seen that a reply was also filed, affidavit in reply was also filed, reiterating, denying to the statements and allegations made in the affidavit in opposition and reiterating to the submission statements so made in the writ petition. In the backdrop of the pleadings, this court have also heard the learned counsels appearing on behalf of the parties. Ms. Swenzo, the learned counsel appearing on behalf of the petitioner, submits that the question of the writ petition being not maintainable does not arise in view of the fact that it is a settled principle of law when the order assailed is in violation to the mandate of Part 3 of the Constitution, a writ petition is maintainable. She therefore submits that the alternative appellate remedy, though available, this court can exercise its jurisdiction under Article 226 of the Constitution. The learned counsel further submits that as the petitioners had title over the land in question could not have been a public land falling within the ambit of the Act of 1971, and as such, the exercise of jurisdiction under the said provision was not at all tenable. Next, the learned counsel for the petitioners further submitted that a perusal of the petitioners here, that it is a settled principle of law as settled by the Supreme Court in the case of Govardhan Das Bhanji versus State of Bombay, reported in AIR 1952 SC, page 16, that public order so made has to be tested on the basis of the contents of the said order, and that cannot be supplemented subsequently by adding reasons by way of an affidavit. The learned counsel further submitted that this position of law have been further explained by the Constitution Bench of Judgment of the Supreme Court in the case of Mohinder Singh Gill versus Election Commission of India, reported in so-and-so, and in that regard referred to paragraph number 8 of the said judgment. The learned counsel submitted that a perusal of the impugned order, both the impugned orders, the perusal of the orders dated 7/10, first one. First one is order dated 7/11/2014, as well as the order dated 7/10/2020, would show that what the petitioners have submitted in the reply was not taken into consideration. However, it is by way of an affidavit, the authorities are, the respondent number two, the responding authorities are trying to give a justification, which is not permissible as per the settled principle of law. Anything more? On the other, per contra, Mr. V.G. Mombi, the learned counsel appearing on behalf of the respondent numbers 1 to 4, submitted that the land in question, that is, the land in question is a part of dark number 416, which is a specifically allotted land to the medical department of the government of Missouri, of the Nagaland. Full. He submitted that in spite of there being a total ban upon the respondent, upon a ban, in spite of a total ban, on granting any allotment or regularization by the deputy commissioners, oblique additional deputy commissioners, oblique subdivisional deputy commissioners, the deputy commissioner in the instant case, by an order dated 6/11/2004, had regularized the patta in favor of the vendor of the petitioners, which was not at all permissible. The learned counsel submitted that these very similar issues arose as to whether the deputy commissioner had the right, in spite of such a ban being imposed. And the division bench of this court have categorically observed that the deputy commissioner could not have exercised such power. In that regard, he reiterated, he referred to the judgment of the division bench in the case of A2, State of Nagaland versus Riaz, in second Namtur, Supra. The learned counsel therefore submitted that as the petitioners in the instant case had no title and the land in question was a public premises within the meaning of section, that section 2, public premises. What is that section?
Section 2.
Section 2, what?
H.
Huh?
2 is public land. Mean any land belonging.
Public land. Public land, there is a definition?
Definition is there.
Show me. Uh, 2H of the Act of 1971. And as such, the exercise of jurisdiction by the authority was in accordance with law, for which no interference is required. He further submitted that the petitioner had an alternative remedy, which the petitioner failed to take into, did not. And as such, this court ought not to exercise its jurisdiction under Article 2 to 6 of the Constitution. This court, upon hearing the learned counsels appearing on behalf of parties and have given an anxious consideration to the respective submissions. This court, the question which therefore arises for consideration is as to whether the respondent authorities were justified in passing, the respondent number 2 was justified in passing the impugned order dated 7/10/2020, as well as dated 7/10/2020, as well as the order dated the first to report, order dated 7/11/2014, as well as the order dated 7/10/2020. Full stop. This court have duly perused the notice which was issued to the petitioner on 21/5/2012, petition number 1 on 21/5/2012, asking the petitioner to show cause. The petitioner had duly submitted her, petitioner number 1 had duly submitted her show cause notice, a reply, giving various details on the basis of which the rights, but on the basis of which the initiation under the provisions of the Act of 1971 was not justifiable, as well as was totally misconceived. Full stop. To the said reply, the petitioner have also enclosed the various documents. On the basis of which the petitioner claimed title over the land in question. However, from the order dated 7/11/2014, it is seen that no reasons have been assigned in the said order as to why the petitioner's reply was not taken into consideration. It is a well settled principle of law that when public authorities exercise jurisdiction, quasi-judicial jurisdiction, reasons have to be assigned, and failure to do so renders the state decision unreasonable and arbitrary, and consequently in violation of Article 14 of the Constitution. It is further noticed that subsequently, in the affidavit, reasons have been assigned as to why the petitioner's reply did not merit consideration. However, it being a settled principle of law as held in the case of Mohinder Singh Gill, to the effect that public orders so made has to be judged on the basis of the reasons assigned in the order and not subsequently by way of an affidavit. In the opinion of this court, the said reasons so assigned in the affidavit cannot be taken into consideration. In this regard, this court finds it relevant to quote paragraph number 8 of the judgment in the case of Mohinder Singh Gill. Next, the consequential the determination so made herein above, the consequential effect of the determination so made herein above is that the order dated 7/11/2014 is unreasonable and arbitrary and thereby violates Article 14. Full stop. It is the settled principle of law that if an order is in violation of Part 3 of the Constitution, this court can exercise jurisdiction under Article 2 to 6 of the Constitution in spite of availability of an alternative and an efficacious remedy. This court further takes note of that subsequently, in the year by the impugned order dated 7/10/2020, the order dated 7/11/2014, basing on the order dated 7/11/2014, directions were issued. It is the opinion of this court that if the order dated 7/11/2014 cannot exist, the consequential order basing on the order dated 7/11/2014 cannot also survive. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. The order dated 7/11/2014 is set aside and quashed. First. Number two, the setting aside of the order dated number two. In view of the setting aside of the order dated 7/11/2014, the consequential order dated 7/10/2020 also cannot survive, for which the same is set aside and quashed. Number three, the setting aside and quashing of the order dated 7/11/2014 as well as 7/10/2020 shall not preclude the respondent authorities to adjudicate on the basis of the notice issued on 21/5 2012, as well as taking into consideration the said reply so submitted by the petitioner, number one, on 4/6/2012. Full stop. Be that as it may. No, full stop. In addition to that, the petition respondents are still at liberty to initiate fresh actions if deemed fit under the Act of 1971. However, if the respondent authority takes such actions of deciding afresh the proceedings in terms with the notice dated 21/5/2012, the petitioner be given an opportunity of hearing. Full stop. This court, next. This court further takes note of the recent judgment of the Supreme Court in the case of in re demolition, reported in so and so, wherein the Supreme Court observed that upon passing of an order of eviction, some reasonable time is to be given to the person concerned, to the person concerned, so that the person can avail the remedy available under the Act. First, in this case, it is seen that an appeal lies under Section 12 of the Act of 1971 against an order of eviction. Full stop. Under such, the said appeal has to be filed within a period of 12 days or 15 days. Mr. Jimomi, which one? 15 days. From the date of 15 days from the date of service of the order on the person concerned. Therefore, this court further observes that in the circumstance an order is passed of eviction under Section 6 of the Act of 1971 against the petitioners, the respondent authority shall not take coercive action against the petitioners for a period of 15 days from the date of the said notice of the order, service of the order upon the petitioners. With the above observations and directions, the writ petition stands dismissed.
For hearing, item number 35.
Oh, 35, they are seeking adjournment or 38? Oh, here, Mr. Yangavati, yes. It's a old matter. What matter is this?
Your Lordship, in the contract agreement, there is a clause for arbitration, for appointment of arbitration, arbitrator.
What are you challenging?
I'm not challenging anything, Lordship. I'm.
This is an arbitration petition.
Yes, Lordship. I'm
You
asking
want,
for,
you want to appoint an arbitrator,
my lord.
and that has not been given. Why you have not appointed till now?
That is why we have approached this honorable court to seeking a direction to appoint an arbitrator.
You are, what matter? This is 11:6. Where's the question, arbitration agreement?
Lordship, in my additional affidavit, Lordship.
Additional.
Additional affidavit.
Where is that arbitration clause?
Yes, Lordship, page 3 is the contract agreement. And the relevant portion is at page 28. 28. Clause 26, Lordship, plus.
In the event of any dispute or difference between the parties, here to such dispute or shall be resolved amicably by mutual consultation or through the good office of the empowered human. In the event of any such dispute or differences relating to the interpretation and application of the provisions of unresolved disputes shall be referred by either of the party to the arbitration of one of the arbitrators in their department of so and so, nominated by the secretary and shall be applicable to the arbitration under the clause. Now, this is not permissible in view of the recent 7 judges bench.
Still, Your Lordship, there is a contract agreement.
So therefore, now you have to appoint somebody.
My lord.
But to do so, you have a panel of arbitrators here?
No.
Where is the dispute? Is it between State of Nagaland or Union?
No, it's between the company, Lordship.
Huh?
Company, firm.
The dispute is between
The contractor.
Union, this is ring. Yeah, and commandant versus here. Okay.
It's a private firm.
Now, why are you seeking an arbitration, Mr. Yangavati?
Lordship, the respondent here.
You want to get the money back?
Yes, Lordship. They have failed to execute the work. If my Lordship may kindly see my parat 9, page 5.
Now, is there any panel of arbitrators?
No.
Then whom should we appoint?
Usually, the union, they appoint one retired officers in other cases.
It can't be from the same department. Now you see that is the problem with the recent judgment. How much is the amount? 3 crores.
It amounts to crore.
Crore.
Yes.
Nowadays, there is another aspect involved. If we appoint an arbitrator, we can't directly appoint an arbitrator. We have to ask the arbitrator whether he has any relation, has he taken up any matters.
Yes.
So he has to submit that, then we can formally appoint.
Yes. The problem is in Nagaland, we don't have panel of arbitrators.
Ah.
We don't have panel of arbitrators in Nagaland.
Let us have it next week. You take your instructions from your people. Who do you? Think about some judge, retired judge. Yeah,
Yes.
I'll also ask that in a principal seat, we have a panel of arbitrators. Get that panel. Huh? On the principal seat, they have a panel of arbitrators.
Panel of arbitrators.
This has already been approved by the Chief Justice, so he has already done it. So from there, maybe. But first, they are in Calcutta. Where's the seat of arbitration? Where's the seat of arbitration? As per your contract?
That I have to report to the.
Because that will be again required, na? We have the seat of arbitration,
Yes.
we appoint somebody here, it will be here. Division of the award to so and so, such circumstances.
Lordship, on the next set, I'll request your lordship.
No,
For the jurisdiction.
I think there will be a seat of arbitration.
Yes, lordship.
If the seat is of arbitration, because you are a central government, you have no
Correct.
problem. It may be in Delhi and all, you can have it very well. You can have a seat of arbitration if it is not there. Have somebody in Delhi, because Delhi has more, they have arbitral tribunals, it can be done fast. In Gauhati, we don't have so much. So there it can be done, your people may think about having it. So if they have any arbitral tribunal out there, so we can very well do that. Just take your instruction. Because you delaying this matter is going to affect you later on. You have although filed it in prime, let's see, and they have not filed a reply. Sure. Mr. Gauhati, the learned CGC, submits that he would take instructions as regards whether the award, the agreement has any specific clause as regards the seat of arbitration. He also would take instructions from his clients as regards the arbitrator who can be appointed in view of the recent judgment of the Supreme Court in the case of Central, is the name of the case, Central Railway. I'll just give it to you. in view of the judgment of the Constitution Bench, in the case of Central Organization for Railway Electrification versus ECI, all caps, SPIC, SMO, MCML, bracket JV, bracket close, a joint venture co. dot reported in 2024 SCC online SC 3219. List again on when, Mr. Angawati? Next week? List again on 12th of December 2024. So the registry shall also place before this court the panel of arbitrators maintained in the principal seat of this court.
For hearing, item number 36.
These are all three words, all caps.
Please, Your Lordship.
Yes, what is this?
Your Lordship, this is for pension, grant of pension to the widow of the.
Pension?
Yes.
You have not got?
No, Lordship.
My lord, I pray that this matter may be listed after petition.
Why?
Here, my senior is the standing counsel for respondent number 10,
This is the response number 10.
Accountant General.
So, you do one thing,
Yes, Lordship.
ask your senior to give something for the Christmas to the petitioner. Pension. Huh? Tell me. Senior is not available. How does it happen? Why is she not got the pension?
Lordship, there was a dispute as to the nominee in the service book. Lordship, it's
Only to extend. Impugn communication letter dated demand only to the extent CNA should not be, we should not be quashed. Grant extraordinary pension, ex gratia lump sum combined with penal interest. Yes.
So Lordship, at page 86, annexure 15, the Inspector General of Police had written that I was remarried after my husband had died. So on that basis, pension was not granted to me. However, I was never remarried, and accordingly, the government has also filed the additional affidavit.
Saying that you have not remarried.
No, Lordship. Yes, Lordship.
Earlier, the report stated that the wife had remarried after the demise of the husband. When the husband died, the department initiated the process for pension, and it sent the documents to the Accountant General's office. Accountant General's letter, it stated that the deceased husband is not entitled for pension because his length of service was less. That's why pension was not granted. Instead, pensionary gratitude was given to the mother of the deceased because the mother was a nominee in the service book. It was like that. And then the petitioners are praying for ex gratia also and extraordinary pension. Extraordinary pension, the ex gratia, it was sanctioned by the government. But since there was
We'll
this.
hear at 2 o'clock.
Okay.
Yes, Mr. Longsha.
Petitioner husband was
How many years of work did your person do?
2 years,
Huh?
less than 3 years.
Then isn't it 10 years?
No, in case of dying, we on duty. The qualified length
Oh,
of
dying on
service is-
duty.
Yes.
Oh, then you get an extraordinary pension.
Annexure 1, page 34. It was mistakenly found fit in accordingly. Material service was issued and page 35 is the type of demand.
So in 1982,
Yes,
when did he die?
84. 27 December 1984, while going for parliamentary election duty.
Okay, so he died in 521.
Then his appointment is at page 36.
Page 38.
36. my lord.
36.
Type copy is 37. Dated 13 September 82. Effective date is 4/9/1982. Then when he died, my lord, age 38. It is medical certificate of handing over to be the patient handed to work to the relative of the deceased. Certified that such and such. That is late Yang Pu Chang. Why? Husband or of Srimati Alam Lajang, that is the petitioner man. Expired on 27/12/1984.
From then, from 1984, nothing has been done.
No.
Okay, now let us see the rules.
It appears that ex gratia was also granted, but it never reached the petitioner. The service book is page 40. Here the page 43 may be seen, my lord. Country rule, the petitioner in the two children are not reflected. So let Benjamin Chang, that is the father, let Nuvan Chang is the mother of the deceased.
So the amount would be paid as on the date on which he would have retired. The
My lord.
family pension?
Yes,
From the date from which he would be deemed to have retired.
my lord.
So he would have deemed to have retired when he was 22 years.
My lord.
And in the meantime, the Nagaland Employment Act had come in.
My lord, it will be up to 31/10 of 2017.
2017.
My lord.
So that will be 35 years.
Age, my lord.
35 years? Wouldn't the Nagaland Employment Act will come? Wouldn't it?
No. Prior to that, it was age.
Prior to that, it was?
It was under superannuation age.
Okay.
Earlier, it was the age. Of course, subsequently, this 35 years is coming to
Earlier, it was still 60, 50.
60, my lord.
60. So then 38 years. And if you consider the Nagaland, it will be 35.
My lord.
So your family pension will be earlier, 2 years before,
My lord.
3 years before. So it will be from 2014. But you are asking from 2017.
Up to.
No, you are asking from 2017.
From 27/12/1984, the day the husband died. Up to 60 years will be 31, then of 2017. That is 60 years.
60. Now, his date of birth, as on the date of his appointment in 1982, was 22 years. 22 years. Because if you see Annexure 1, can you see Annexure 1?
My lord. About 22 years. Yes.
So we'll have to calculate it as 22 years
It
in
will
the
be,
82.
yes.
We can't change that. So, so 22 years, then 60 will be another 38 years.
Mal.
So 82 to 38 will be
84 to
20. 38 will be 2020.
What?
38 plus 82.
With effect from 4/9/1982.
2020. So if we calculate, it will be 2020. 2020. So from 2020, you will be entitled to family pension.
Yes.
You'll be entitled to the family pension.
Yes.
Now, you have not remarried.
No.
So therefore, you are entitled to.
No.
That is your case.
No. That is my whole case. Much obliged.
After the husband died, the department initiated the family pension process. But then the accountant general, from their office, they state that the deceased constable was not entitled because of the less number of years. So from there.
But what do you say about page 91? That's the notification of the government of Nagaland, which was holding the field at the time when he died.
Yes, Your Lordship, but this relates to.
Kindly come to
officers
number
killed
3, paragraph 3 of that notification.
Yes, Your Lordship, but this relates to those who die in encounter or those who were killed in action only, Your Lordship. The heading itself says that the subject. Officers killed in action.
Action/encounter or hazardous situation
But he
while
was-
on duty shall be equal to the last pay in allowance drawn by the deceased police personnel and shall be admissible at the same rate till the date on which the deceased heir would have retired on superannuation had he continued in service. Thereafter, the date on which the deceased would have superannuated. How did he die?
He died in a vehicular accident, Your Lordship, not in encounter or not during, he did not die in action or encounter, but in a vehicular accident.
So anybody who dies in a vehicular accident while during the process of being in duty, he would not be entitled to anything.
But Your Lordship, this notification clearly states that those who are killed in action and encounter only.
Action means you can very well develop the idea of action further. You can't limit it. He has, just for example, a person tomorrow he's going for, there's some shooting out there anywhere. So he's going on his way on a vehicle and the vehicle meets with an accident. No action. I'm asking you. Let us be more knowledgeable from there. He has been asked to be in duty in a case pertaining to elections. So during the process, while he was going, he met with an accident.
Yes, Your Lordship.
You paid him 10,000 rupees ex gratia.
No, Your Lordship, ex gratia was sanctioned, but it could not be released because there was conflict between the wife and the
But
mother.
that is a different thing. You have not released because who is going to get apportioned that amount is a different aspect. We are not concerned with that. But you have granted the ex gratia under what provision?
Because he died in service, Your Lordship.
No, you give it on basis of number 2.
Yes, Your Lordship.
So if you are doing it for number 2, why not number 3 would not come into the picture? Isn't it, Mr. Longshore?
Otherwise, also was for the. Yes, problem not Naklan. Based on the Government of India, Ministry of Personal and Public Grievances in Pension. 11 September 1998.
1990.
1998. 11 September, that is in continuation of that 1990.
Age?
Same volume, but after 1990.
11 December.
September.
11 September. Special benefits in the case of death in
My lord.
service of ex gratia lump sum compensation who die in harness.
The action encounter, yes, it may be. When it is action, somebody dying in the war, like situation it is, the compensation is high.
But Mr. Longshore, tell me, this only came in 1998.
No, I understand.
What about the
Yes.
1982? Because unless you come under this Office Memorandum of 14th of January 1980, because that was holding the field.
Yes, I agree to that.
So the only option is you
Yes.
have to come within the ambit of police personnel killed in action oblique encounter or hazardous situation. So can we explore to say that the hazardous circumstances which happened in the instant case or the death occurred to the husband on account of hazardous situations?
The duty itself is a hazardous.
So
Police
unless
personnel.
we can bring it within the hazardous circumstances, it would not come under the application of action or encounter. It would not. So, but or hazardous situation. It could come under hazardous circumstances, but can we say so in the present facts? That is the only thing. So you have to therefore apply on the facts as to whether in the instant case, it would come within the ambit of hazardous circumstance. If it comes within hazardous, we bring you. If it does not, isn't that, madam?
Yes, Your Lordship.
So how did he die? Where is anything mentioned? How did he die?
My lord, in my petition, I've included a similar decision of this honorable court.
Is it? Where?
Yes, page 114.
114. Here, there's a difference, Mr. Longshore. Kindly see the paragraph 3, the last line, last two
Yes,
line.
a tragic situation occurred when the petitioner husband during the period when he was undergoing basic training to Muslima suffered death at the hand of unidentified gun.
So therefore,
in the crossfire between two extremists fighting.
but here vehicle. How do you take care of that? And madam is very rigid to her submissions.
Yeah, of course, without my client, even if the petitioner in the children, they are taking that stance. But if it is that stance, at least the petitioner in their family should have been granted what they were entitled pension.
Kindly see, come to paragraph 6 of that judgment itself.
That respondent basically on the ground that the benefit of OM 1995 will not be available to the respondent petitioner in as much as the husband of the respondent petitioner did not suffer death while on duty or while in action in encounter. In this case, they've taken that stance.
And the contention therein was, as he was in basic training, he was not in active duty.
No.
No, that was the case.
Yes, yes.
In this writ appeal.
Yes.
So the division bench held that yes, for the purpose of that, taking into account the FR, said that yes, he was in active duty, and as such, as he was killed by a gunman, so he was entitled.
Malo.
But the problem arises whether that same aspect would have been applied here, unless you say that brings something to the effect that he died out of hazardous action.
Malo, the OEM which I placed before the Lord.
This is of 98.
My Lord.
Long time after. Long time.
My Lord, when the decision takes, it has to be on that basis. It cannot be.
Isn't it the
If
law?
they have taken the decision way back in 1984 or 85. But the issue is deciding only today. So what?
But the entitlement of a person,
yes,
would depend upon when the cause of action happened. The cause of action happened upon the death of the person concerned in the year 1984, when it was that was in 1980.
My Lord, that aspect, that is why I'm saying that I may be allowed to consent.
1995 also, if we see the 1995 as quoted out here, the liberalization, the order shall all government who are killed while performing bona fides shall be entitled to ex gratia grant. The family pension here shall be granted or paid by the government as an ex gratia. Yeah. So this notification, if it comes, we are to apply the 95. If we can apply 95, then you can get it. But the question is, can we apply 95 and not 98?
When somebody died in 84.
No, but how do you then take care of 98 then? 98 again says about action.
No, my Lord, 98, I may be allowed to take your worship.
And her right to get the family pension accrued in 2020. 38, 60, 22.
Family pension will be entitled. See, normal. If somebody have died, see, on 27/12 of 1984, from that day,
she'll be entitled.
And from the next day.
So as on that date, she was not entitled. unless you bring it within the hazardous action.
No, when somebody died, well, on bona fide government duty, it is totally a different issue. Somebody may die even on the first day of the duty. So the question of qualifying length of service
No,
doesn't arise.
therefore,
Yes,
they have given a liberalized, it is therefore said to be a liberalized family pension.
ma'am.
Why it is saying to be liberalized is you don't need to have the 10 years minimum,
No.
which is otherwise required.
Extraordinary pension
Is given
itself
under
is
such
clear.
circumstances. So this
Yes.
is a liberalized, taking into account that somebody dies, because her entitlement will accrue in 1984.
My lord.
And 1984, if that accruement, it accrues, 1984, then it would be covered by the 1980. Subsequently, the government decides anything in respect to AI, it would always be prospective. And why didn't you apply then? Why did you apply now? Why the petition was filed such late time, 2022?
There was the earlier proceeding, a lot of people. Page 1380.
This is also in 2017.
Yes.
But this is also very much delayed.
My lord, this question has been settled in my standing by the Supreme Court when somebody is ignorant, because the petitioner is from a declared backward tribe of Nato. My read petition.
Mr.
Para-
Longshore.
Yes.
The sad part is, one matter I disposed of, there were 3 writ petitions where your persons had a right to be promoted. Some inspector, SI or something, remember?
No, I was not there.
No, you were there. The SI,
Yes.
you remember UBI,
Yes.
didn't it? There also, I said that you are entitled, but there is a delay.
Malo.
That is why I said that now to disturb, and you have allowed everything to attain. That's a seniority list or something.
Yes, seniority.
Here also, you were entitled, first let us say, you were entitled in 1984 as per the 1980. Unless you come up within the ambit of hazardous circumstances, show me anything which shows that you later on they were still considering. Let us see that if you have any document to that effect. Because the representation was given in 2014. Legal notice, page 76. Then submission of inquiry report. Then again submitting another representation. After your representation, what did they do?
$86 million.
Finally come to page 86.
My lord.
paragraph number 3, the service benefits such as
Family
FBP,
benefit fund.
FBF. What is
Yes.
that? FBF?
Family benefit fund.
Huh?
Family benefit fund.
Family benefit fund.
Yes.
Leave
Leave
encashment,
encashment, GPF, death
GPF,
gratuity.
and death gratuity in respect to the corner was settled and paid to the deceased mother since so and so here. It is therefore requested that the government may kindly take up the matter with the PNR department and issue necessary to dispose of the representation.
So it was offended.
Then what happened?
Come that somebody was female, which
Thereafter, what decision have you taken? After that, in 2016? Madam, what decision have you taken after page 86?
Your Lordship, after this, the writ petition was filed, Your Lordship.
This petition was filed immediately. Now, what decision have you taken from here? Have you taken any decision? Because they didn't do anything.
Yes, Your Lordship.
By this, they said they did not pay. Then they submitted the non-marriage certificate.
Yes, Your Lordship.
But you have not taken any decision on this.
Yes, Your Lordship.
Mr. Longchar, can we therefore, taking into account this, no steps were taken pursuant to this 2017 disposal of directing the authorities to consider and take a decision taking into account that you are not married?
my lord. Then there is a verification report as per this honorable court.
No, it's okay. We say that you are not married. So under such circumstances, whether you are entitled to family pension, we can do that.
I've understood.
But it would only result in another round of litigation by you. Think about it.
Will it be better if my learned friend is directed to take the instruction? What happened to this? As per your lordship has pointed out.
And she says that after that they filed writ petition. You filed writ petition, they didn't do anything.
No.
So therefore, I can do that. But you see, one has to also take note of that the petitioner, as on date, is fighting. She doesn't have any source of income.
No.
So asking her again to, because they will reject it in view of their stand now being taken that he is not entitled to the family pension. Would it would this amount to my order, if I pass them to further conclude on the basis thereof, would be a closer to the decision what actually the petitioner wants? You see, at the end of the day, you have to take note of, yes, it's a big company, they can keep on fighting litigations. Here is a lady who have not got anything. And as such, she's, however, pursuing her remedies before the court to get something on account of the death of her husband. So unless, I think it would be better for disclose yes or no, maybe I dismiss it. But the question is, some closure has to be there. I give you an opportunity to find out somewhere, what does hazardous action mean? Would it also include, because election duty, we has to remember, Nagaland in 84, election duty was, I think, more than hazardous.
Even to thee.
Huh?
Even to thee.
So, if you think something we can bring in somewhere, I want to do something for the ear of the petitioner, but if you don't give me something, I am not. So that is how you have to help this court to give you. But directing them now with their stand that they are not entitled in view of the 1980 because it is not a hazardous sale, they will immediately reject it. Which means you have to again come back.
Malo.
Which I don't think would be a closer to the case of the petitioner. she'll again have to fight, keep on fighting. So give me something. Not under 95. 95 cannot hold the field. It has to be on the basis of 1980.
Otherwise also, my lord, if I not, of course, I don't have the book. Extraordinary pension will be applicable to the family. When
Which one?
somebody have died unduly.
No, therefore, I think you are entitled to. But it cannot be in such a manner that, okay, somebody dies out of police action, but a person is going to the police action, he is not entitled. However, if you see the illustrations here,
yes,
these have I would not have otherwise think. Kindly come to page this 227.
That is 11 September 1998, isn't it?
Yes, yes, 9th of April 1990. There are few illustrations given. 1, 2, and 3. You kindly see this.
My lord,
you have that book? Same book?
Yes.
Kindly come to page
Contempt, but page are different.
Huh?
Page are different.
Page 2 to 6,
Yes.
yeah. Illustration 1. Officers of the income tax, custom, excise, police proceed to carry out a raid. If on the way any member of the team with an exam while traveling in public so-and-so or otherwise, the family shall not be allowed the benefit of these orders as the injury in such a case not due to an actual operation. You see this?
My lord,
this is what is the problem I'm facing.
My lord, I may be allowed to hit your lordship to 11 September 1998. OEM by the ministry.
11th?
11
September
1998.
Yes.
This clearly speaks about special benefit in case of death in disability in service. Payment of extra lump sum, compensation to families of family, federal government civilian employees who die in harness. Recommendation of the fifth Central Pay Commission.
Now, you see, Mr. Longcha, after 1995, there is a shift. Anybody in active government duty would be entitled. 1995, which was duly taken into consideration by the division bench. So that was taken into consideration by division bench. But we are concerned in 1990, 80. And if you see, in 1990, the understanding is if you go on a journey to meet, to carry out a raid, or for your, then also you are not entitled to the liberalized pension, even in 1990. 1995 is a different aspect which came into. So prior to that, 1990 also says that you are not entitled. That is why I'm saying this, because I was earlier asking her that. But then I saw this illustration which gives a different aspect.
My lord, with 11 September 1998, OEM is accompanied with annexee. Para 5, I maybe take your lordship. Para 5, that is in the OEM. In superstition of all earlier orders issued by government as well as by the individual ministries in departments, insofar as these relate to the payment of ex gratia lump sum compensation, in certain specified circumstances, the President is pleased to say that families of central government civilian employees who die in harness in the performance of their bona fide official duties under various circumstances shall be paid the following ex gratia lump sum compensation. Your Lordship has pointed out the difference. A is death occurring due to accident in the course of performance of duty, that is 5 lakhs. Then C, indemnity, sin my lord. Death occurring during A, enemy action in international war or border skirmishes, and action against militants, terrorists, extremists, etc. is 7.50. That is higher. Then, my lord, I may be allowed to take your lordship after the annexee. Illustrative example of cases covered under the different clauses of para 5. What I read out, my lord. So it is A, B, C, and D. So they've given here illustratively in clause A, date attributable to accident while on duty. 1. Date as a result of an accident while traveling in public, private, or official vehicle or otherwise. Our great day employee, such and such, messenger, postman, notice service, duty to distribute that notices, etc., or personal and field duties. To the asking what on field duty. Then, who is date occurring due to accident while traveling on bona fide official duties in a service aircraft.
But none of these come within you. 1 to 12 does not come. Just for example, 1 comes for only for those duck. Number 2 comes for those who are traveling by service aircrafts.
No, one includes, my lord.
Or otherwise of group D employees, dispatch riders.
My lord, or personal.
No, you see those people, dispatch rider, messenger, postman, notice server, etc., deputed to distribute the notice, etc., of personnel on field duty.
Or personal.
Or of personnel means, just for example, somebody gives a duck for somebody is in the army, so he sends some duck to somebody at home. An accident happens, so therefore they will come. They are very specific here. Kindly see. Number 2, when somebody is there in the service aircraft,
etc., or a personal one. A personal and
Number 3, accident during test flight. These are very specific. None of this comes with you. I thought of number 5, accident to ships, river steamers, etc., resulting in death. But here again, they are saying anything which is moving in water. They're very specific here. But they don't say anything about vehicular. Death as a result of injury or again
accidents.
Understood. To whom? Personnel of income tax and customs, so going for raid.
No. Number 6 is very clear.
Yes. Customs and Central Excise Department, Central Police Organization, etc., while proceeding on raid against tax evaders and anti-social. You didn't go there.
That is why I am conceding before your lordship that even taking the worst view of the matter, the petitioner in the 2 children, they are entitled for family pension.
How?
Since somebody died while performing duty.
But that was not the law then. Your entitlement came in 1984. At that time, that was not that. The only liberalized pension which came in 1995.
At that time, extraordinary pension was
there, but
yes.
There, but it was liberalized. Extraordinary pension. Let us see what is extraordinary pension. Where is the pension, extraordinary pension? Will be there in the CCS books, na? These are all subsequent. Unless you can attribute these to others. Okay, Mr. Longshore, we'll have it again next Tuesday. You find out some judgment to the effect that if the matter is pending, this court can import the latest of the notifications.
Yes.
But latest of the notifications, that is what. Otherwise, 1980, there is a difficulty. And I don't want to put the further agony of sending it and then they reject, which they are going to reject. And you have to get it, you have to get it, otherwise. Or have it after the winter vacation. Some more kinder judge will be there. Which one? The more kinder judge or more fairer judge? As per him, I am an unfair judge.
No, my lord, I am very sorry that I don't choose any particular judge.
No, the thing is this, I don't want to, I want that your client should have a closure. Either she should get it or she should not get it. I'm not going to send it to them. Because if I send it to them, it is nothing but just putting you to the death. But thereby, I would be abdicating my duty of doing what was actually necessary, which I am not going to do it, to send it to them. So therefore, you are to therefore show me, yes, you would come within the ambit of hazardous or there are certain judgments where the Supreme Court have taken into consideration or a division bench of this court have taken into consideration the subsequent notification or the notification when the writ petition is being filed. If a Supreme Court has done it, then it is permissible, one can do so. But for me to apply that notification of a later period is difficult because that cannot be the law as per me. So the only way out is hazardous circumstances. Now, hazardous circumstances, if we see the 1990 illustrations, it makes it very clear. However, in 1998, illustration A was modified. And thereby, those people who central or anybody going for a raid also has been brought in within the ambit of a liberalized pension. So therefore, you think about it, what to do next week or after vacation.
Next week?
Heard Mr. Longshore, the learned counsel appearing on behalf of the petitioner, Ms. So-and-so appears on behalf of the state of Nagaland. And so appears on behalf of the accountant general. This matter having been heard at length, lists this matter again on 12th of December 2024 as showing it as part of it. Let's take this book, Mr. Longshore.
For hearing, item number 37.
Please, Your Lordship. Lordship, I beg to mention on behalf of my colleague, government advocate, Ms. S. Chang. She was supposed to file her additional affidavit, but since due to her being indisposed these few days, she was unable to do so. So she prays that if the matter can be listed next week, by which time the affidavit will be filed, Your Lordship.
Affidavit in reply.
No, additional affidavit, Your Lordship.
Counsel appearing on behalf of the petitioner seeks some time for
Respondent,
filing.
respondents for
By
the
respondent
state
to file
respondent.
an additional affidavit. You are a work charge?
Yes, I'm a contingency page.
Contingency does not come under two thousand
My
four.
lord, to that extent, I have a judgment of this noble court also, that contingency and the work charge, they are equal.
No, no, no. This is only for work charge.
Yes. I'll
Two
satisfy to
thousand four
that.
notification is only for work charge.
Yes, my lord. To that
Then
extent, I'll
how do you
satisfy.
come into picture?
My lord, I'll satisfy you, my lord. There's a judgment of this honorable court,
Where?
my lord. Page 43, Annex N. The operative portion is at page 56, paragraph 40.
This is a single bench judge.
Yes, my lord.
Where he says that the contingency is same.
Yes, my lord.
Why?
Paragraph 40, my lord. Page 56.
Para?
Paragraph 40, page 56. Last line, my lord. Paragraph 40. May I read, my lord? The contention that the petitioners are not work charge employees is examined, and it is found that the contingency paid employees and work charge employees are terminologies used for the same purpose. Both work charge employees and contingency employees must be terminable at certain stage. However, the state government.
What has happened to this judgment? This has been set aside.
My lord.
Does this judgment remain?
Yes, my lord.
I'm not very.
Government? You are government?
Yes, Lordship. I'm not aware, Lordship. Sorry.
No, no, there are many judgments that they have to therefore challenge the 2004 not taking into account the contingency. Contingency is different from work charge. Work charges are different. Work charges are specifically defined in that Act of 2001. Work charge is not defined with contingency. This aspect have not been taken. No, no, no. 2004 is specifically work charge.
Yes.
These are large numbers of work charge employees in various departments, many of these employees here. Whereas contingency has been specifically taken in the 2015 notification. Anyways, he wants to file an affidavit. No?
Yes.
Better off. The council appearing on behalf of the respondent submits that he would like to file an additional affidavit in the matter, list this matter of revocations.
Lordship.
For hearing, item number 38.
Yeah, please, Lordship. Lordship, I'm making mention on behalf of the leading counsel for the appellant, Lordship. Manas Das Gupta.
Oh, 38, yes.
Yes, Lordship.
Okay, at the request of the council for the petitioner, matters in John to be listed
After
after
vacation.
vacations. His wife is not well.
Yes, Lordship, he's going under medical treatment, Lordship. Much obliged, Lordship.
For hearing, item numbers 39 and 40.
What is this?
NDPS,
NDPS.
my lord. Punjab, Lordship.
How long you are inside?
More than 3 years, Lordship. About 3 years, Lordship.
3 years.
Yes.
What is the quantity?
360
Grams,
Lordship,
kilos
kgs.
of ganja?
Yes, cannabis leaves, Lordship.
What is your ground?
That, Lordship, page 120
What is your ground?
of that, Lordship, they have it has not been proved that the seized items are ganja, Lordship, from their FSL report, Lordship, because, Lordship, the chemical percentage there is a certain chemical which is present in ganja that is not mentioned, Lordship, and Lordship, a description must be given, Lordship, that it is containing flowering tops and fruiting tops, because cannabis leaves, Lordship, it is not punishable under the NDPS Act, Lordship. My Lord is well aware. So
I'm not aware. Yes. Yes, tell me.
Yes, I have judgments on that, Lord.
So do you say that the fact that this is ganja
Yes,
has not been proved?
yes, my Lord. If my Lord may.
Now, has there been a compliance to 52A?
52A, Lordship? It has not been properly complied, Lordship.
What is this properly complied or not? What is properly?
Lordship, because there are certain conditions which must be fulfilled for the
Whether the document has been proved?
improper inventory, Lordship. No packaging numbering, no packaging, Lordship, no numbering. Weight has also not been mentioned, Lordship. Seal and signature is not there, Lordship. And then the remnants which were sent to the FSL, Lordship, it must be returned back. That is also not there, Lordship. And Lordship, it has been deposed by the seizing witnesses also that the seal and signature in the packaging is missing, Lordship. And they are unable to say whether those items are the ones which was seized on that particular day, that the ones which was produced on the day the depositions were recorded, Lordship. PW2, PW1, Lordship, PW5, all
Who are the PWs?
One is the officer in charge of the police station, Lordship. He, after the arrest was made by the constable, Lordship, who is an empowered officer actually. He went, Lordship, to the site, and then Lordship, seizure was made. So he has categorically stated in his deposition, Lordship, that it is correct to say that there is no mark or seal on the seized ganja produced before the court today. It is correct to state that the seized ganja produced before the court does not bear any proper packaging. So there is chances of pilferage, Lordship.
So the person who seized it.
Yes, who is the officer in charge of the police station, Lordship. It is examined.
He seized it.
Yes, Lordship.
Now, thereupon, he must have produced it at the time of packaging.
Yes, Lordship.
He must have done it before the magistrate.
Yes, Lordship.
Has he done it?
The packaging, it appears it has been done before by the police themselves, Lordship.
Before the magistrate or not?
Lordship, and Lordship is this thing, the samples, Lordship, it was drawn before the magistrate, Lordship.
It was done.
Yes, Lordship.
Okay, then the magistrate, it was done. Now,
Yes,
has the
Lordship.
magistrate given evidence?
No, Lordship.
Who has proved that it was done in front of the magistrate?
PW6, Lordship.
Who is he?
The IO, Lordship. The IO of the
IO
case.
says that this was done before the magistrate.
Yes, Lordship.
And he has proved the signature.
Yes, Lordship. In fact, the absence of seal and absence of proper packaging, Lordship, has also been stated by the other seizing witnesses also, who are police personnel, Lordship. PW2, PW5, Lordship.
So the initial burden was discharged?
No, Lordship. And Lordship, the arrest, Lordship, was made by a constable, Lordship, which is not permissible, Lordship, as per the NDPS Act, Lordship.
Arrest.
Yes, Lordship.
But the seizure was made by somebody else.
Yes, Lordship.
It was from a truck.
Yes, Lordship.
Isn't it?
Gypsy, Lordship, gypsy, a white gypsy.
White gypsy.
Yes, Lordship.
Gypsy's owner is who?
Gypsies?
Owner?
Owner, Lordship? I am not the owner.
You are not the-
No, Lordship.
Chalo. Why there are two appeals? One is bail.
Yes, Lordship.
You are inside.
Yes, my Lord. For more than 3 years.
To grant you the bail, the problem is one has to come to a finding
Yes, my Lord.
that you have not done the work.
Yes, my Lord.
It's very difficult. So better dispose of the appeal. Isn't it? Let us see the paper book. Where is the paper book? Paper book? Paper book. Why there are two paper books?
That I'm not aware, but we prepared only one, Lordship. Maybe there's an additional copy, Lordship.
Synopsis, appeal memo, so and so FI arrest, so and
Second
so
copy.
seizure memo, medical report exhibited, medical report. Seizure report, inventory under 50.
Lordship, may kindly turn to page 120 of the paper book, Lordship.
17.
This goes to the root of the matter, Lordship.
So this was certified
Yes,
by
Lordship.
the judicial magistrate. It was done properly. Contraband. Ganja unknown 360 kilos packed in 36 regular packets of 10 months serial number. It was packed in. And certification based the magistrate certified that the above infringement requires satisfied that the above infringement. So this is how it was packed.
Yes, my lord.
Then superintendent is advising the parcel consisted of 10 exhibits mentioned and closed in yellow envelope. Description results the exhibited marks and are found without cannabis.
But they were unable to prove that whether the items seized on that particular day were the items produced on that day before the court, lordship. Because without seal,
Why is it required to be produced?
lordship, the seal must be present, the packaging number, each seized contraband, lordship, a packaging number is given, lordship.
Why is it
And it is,
required to
and it is
produce? No, why
kept,
is it required to be produced?
and it is kept in the
contraband.
custody of the,
No, once 52A is being complied with, is it
My
required to produce?
it must be kept in the safe custody of
Just for
the,
example, let us take the case of a death. A person is the dead body.
lordship, but,
Dead body?
yes, lordship, but,
Are you
lordship,
required to produce it?
the, be that as may, lordship, whether it was required or not, lordship, but lordship, it was produced, lordship.
No, whatever may be, but once 52A is being done,
Yes, my lord.
sampling is being done.
Yes.
We are not concerned with the quantity.
Yes,
The
lordship.
sampling has been done. With the sampling, it is being found that yes, the sampling is being proved.
Yes, lord.
To the effect that it was done under 52A properly by the magistrate in presence of magistrate. The magistrate had put the seal and this has gone to that FSL and the FSL has then come up with a report to the effect, yes, it is positive of cannabis. Then under such circumstances, it is already done. That day I was reading through one very important material. Why material exhibit is not evidence? Tell me. You are an expert in criminal life. Tell me, I don't do criminal. Why material exhibit is not evidence? You see, what are evidence? Oral?
Yes, lordship.
And documentary.
Yes, my lord.
Documentary includes electronic.
Yes, my lord. My lord. Now, lordship.
And also, nowadays, electronic and in view of the BSA, another one is there. What is that? Digital. Digital record. Why material exhibit is not evidence? Material exhibit is not evidence because of the fact that material exhibits can be proved with documentary evidence.
Yes, lordship.
That is why there's one, you must have read one law of evidence by Stephen Fry.
Yes, my lord.
He's one of the considered to be one of the most important persons on evidence. So he has stated that why it is not required a material exhibit.
Yes, my lord.
Now tell me, what is there, therefore, to
Now,
bring
lordship.
that this was produced? They have made the AR under 52A, so that
Yes.
has been done.
Lordship, they were, before I come to that, lordship, 52A, lordship, firstly, lordship, the very definition of ganja under the NDPS Act, and lordship, my case is that, lordship, the prosecution, lordship, they were not able to establish the foundational fact that even prima facie, lordship, that ganja was seized, lordship. They were unable to prove the foundational fact, lordship, that ganja, which is a prohibited substance under the NDPS Act, was seized, lordship. Lordship, may kindly may I refer to section 2, lordship, of the NDPS Act, 2(3)B, lordship. 2(3)B in my book, lordship, it is page number 4. This is page 4. 3B, lordship. Yes,
ganja.
yes, ganja.
That is
Under cannabis, lordship, yes. Ganja, that is the flowering or fruiting tops of the cannabis plant, excluding the seeds and leaves when not accompanied by the tops, by whatever name they may be known or designated, Lordship. Now, my lord,
Then,
in the inventory, Lordship, there is not, in that 52A document, Lordship, there is no description of the items that they have seized, Lordship. That, Lordship, the seized item contains flowering or fruiting tops, Lordship.
who said?
In the inventory, Lordship.
No, here it says it is cannabis ganja
No, Lordship.
in the page 122,
No,
120
Lordship, but Lordship.
FSL report.
Yes, Lordship.
Now,
I'll come
did
to
you
that.
challenge the FSL report during a cross?
Now, Lordship, if I may be allowed to.
Did you challenge the FSL report during cross?
No, my lord.
No. Come to that point. Did you challenge the FSL report during cross?
Lordship, but Lordship, the question of law, the fundamental question of law, Lordship, it has to be satisfied, Lordship.
No, the fundamental question of
Yes.
law here is
Yes.
whether the initial burden has been satisfied. Now see,
Yes.
seizure done,
Yes.
packaging done,
Yes.
52A complied with.
No, it was not complied, Lordship.
It was
52.
complied with.
In 52A, Lordship, there are certain requirements, Lordship. I'll come to that, Lordship, later, Lordship. But
No, as of now, unless you come to it, we have to assume that it has been
My lord.
complied with. FSL comes, FSL categorically says that it is cannabis
Yes.
ganja.
Cannabis
So,
ganja, Lordship.
ganja, it says.
Yes.
Now the question is, this is the initial burden.
Yes.
Once it is there,
Yes.
in view of the presumption, now under 38 or 54,
Yes, my lord.
these are two provisions.
Yes,
of
yes,
the-
my lord, my lord.
The presumption now is there, so you are to therefore rebut that presumption.
Yes, my lord.
So what did you do?
Now, Lordship, I may be allowed to read paragraph 9, Lordship, from
Oh.
that judgment that I have placed, Lordship. That, Lordship, the
Oh.
judgment that,
Judgment later. First of all, you show me here.
Lordship, there is a chemical, Lordship, tetrahydrocannabinol, Lordship, which must be present in ganja, Lordship, 25%, Lordship, for it to be qualified as ganja, Lordship, as per the NDPS Act. Now, here, Lordship, there is not a single whisper.
No, Mr. Counsel, did you hear it exhibited mark as so-and-so on tests were found to be cannabis
Yes.
ganja?
Yes.
This is the report.
Yes,
Did you
Lordship.
cross-examine on this?
The Lordship, the examiner, chemical examiner, he was never summoned by the court, Lordship. He was not summoned, Lordship. He was not a PW, Lordship, the chemical examiner. Because this question can be put only to the chemical examiner, Lordship. And if, Lordship,
Did you put the question to the prosecution, anybody?
no, Lordship.
Then,
Lordship, if a chance can be given so that the chemical examiner will be summoned, Lordship, and this question shall be put to him, because, Lordship,
no, that is the question of remand. This is not CPC. This is criminal.
Yes, my lord, but then, my
Mr.
lord,
Bas, you should have put that question. That would have created the reasonable doubt.
Lordship, but that chance never occurred because the chemical examiner
Did
was
you
never
at
summoned.
any point of time challenge this report anywhere in your cross-examination?
That, Lordship, I'll have to see, Lordship, but to the best of my knowledge, unless I.
Yes,
I
Mr.
may-
Angami,
yes,
what do you
Lordship.
say?
I may require some time, Lordship, to go through the cross-exam depositions again, Lordship.
What do you say?
My court had already observed as far as the other things is examined, but not only what has been examined now, but the convict himself has admitted that he was carrying ganja. All that he said was before under 313 when he was examined, he said that he was carrying ganja. All that he did not know was the quantity. This admitted fact even before under
313 is not evidence.
but still then he has said nobody compelled him to say it. And
And-
even under 161 he said the same thing. So he was in conscious possession of ganja.
for a sum of rupees 10,000.
Convictions cannot be based on statements under 313.
Now,
Convictions shall not be on the basis of 313, but the fact that you were given an opportunity. Here you see, you have to, initial burden, has it been done? It seems it has been done. So therefore, your burden now was to rebut it.
Yes, Lord.
How could you have rebutted it? You could have put that question to the effect that this couldn't have been, there's no report is silent unless you show me some judgment to the effect that in the report which is to be given by the FSL, it categorically mentions that it has to also mention in what are the quantities of the ganja, which portion is what and what not.
Lordship, but like I said, Lordship, the chemical examiner, he was never a prosecution
Is it
witness.
required?
He was not summoned by the court, Lordship.
Is it required?
Perhaps in the
No, are you saying that without the chemical examiner's report being approved
yes, my lord.
by the chemical examiner,
Yes, my lord.
the court would not have come to a finding
Yes.
that was cannabis?
Yes, Lordship, Lordship. Because if
For that-
if he had deposed that it contained flowering and fruiting tops, Lordship, then
No. Here the report is very clear. See, this is cannabis ganja. Says that. Falls within the meaning of this drugs. Now the question is it your submission that without the chemical examiner being exhibited, the report of the chemical examiner could not have been proved without the presence of the chemical examiner?
because Lordship, the FSL report, it should not be given in this manner. It should not be given in this manner. The FSL report prepared from the FSL lab, Nagaland Timapur, Lordship. It should not be prepared in this manner, Lordship.
Why?
Lordship, that is why I wanted to place some rulings, Lordship.
What?
On that. How the chemical reports must be, Lordship.
Show me from the act, then I'll see judgment.
The act, Lordship, under section 2B, it says that ganja, the cannabis leaves must be accompanied by the flowering and all the fruiting tops, Lordship. And if it is not accompanied by those, Lordship,
Take another one, no? That's the second copy or the first copy? There are two copies, I suppose, no?
it's the same, I believe. I believe, Lordship, it is the second copy. We have prepared only one paper book.
Okay, statement of the complainant, second final form. As memo deposition, 135. Okay, it's here. 135. 135. If I so and so, I'm serving on the amount 36 with unregistered amount is Ipsy and Manicolan registered, identify PH, the fire. It's correct to state that there was slight difference in the weight of the contract. Yeah, it only identified that it used now. Yeah. How many years?
10 years, Lordship.
Only. Can we extend it? We hear further tomorrow,
My lord.
this matter tomorrow. 2 p.m. You may be busy in other matters, so maybe
No,
you can't
my lord,
see.
my lord.
We'll have it at 2 p.m.
My lord.
2 p.m. Sure.
Much obliged. Saya tu bapak sekolah. Alif plus 4 dah.